Hi, I'm Jeff Peak with the Peak Law Group, and I'm joined today by Joey Cantu and Teresita Rodriguez, two experts in their area of both criminal defense and immigration. And we are here to talk today about Senate Bill 4, the new legislation out of Texas that is basically going to criminalize unlawful presence or unlawful entry into the state. It just was passed by the Senate. It's going to the governor Abbott's desk. We imagine he's absolutely going to sign as quick as possible, knowing how strongly he feels against illegal immigration. So we're here to talk about that law and how it might possibly affect you. So before we get to everything, again, Joey Cantu is one of our senior defense attorneys. He's been doing it almost 12 years. Tried everything from murders on down to the small stuff, and he's going to bring his legal expertise here. Teresita Rodriguez also has been an immigration lawyer for over a decade, doing everything from removal defense to family-based employment, you name it. So you have a great panel of experts here today to talk about this. So Senate Bill 4, in part, team says illegal entry from a foreign nation. A person who is an alien commits an offense if this person enters or attempts to enter this state, meaning Texas, directly from a foreign nation at any location other than a lawful port of entry. Joe, you've had a chance to look at this. What are your thoughts right out of the gate, not just the initial crime, but some of the affirmative defenses and enhancements?
Sure, Jeff. Well, this new act does create three different crimes. The first one being illegal entry, as you just stated. There's two different levels of severity that this could be charged under. It could either be a Class B misdemeanor with a maximum of 6 months in jail, or it could be as serious as a state jail felony with up to 2 years in prison if the person has previously been convicted of this same offense before. Again, the second and third crimes that are created by this are illegal re-entry, which is basically what it sounds like if you have been excluded from the country previously and you are found in the state of Texas. That can also be a crime as low as a Class A misdemeanor to a third-degree felony. The third crime created by this is if you fail to comply with a Texas judge's order to leave the state, that can be punished as a second-degree felony. So as far as what defenses can one rely on if you're charged with this in the future, there are affirmative defenses lined out in the statute itself, and they mainly relate to individuals who, just checking my notes here, are...
Well, one of my notes, if you had deferred action, DACA, that would be an affirmative defense.
If you are able to prove, and again, the burden would be, it seems like it would be on the defendant here in this statute, to prove that you are lawfully present in the country or under having granted asylum as well. There are certain, immigration programs that are not covered as far as being an affirmative defense to prosecution here. And those would be deferred action for parents of Americans, as well as lawful permanent resident programs. Those will not immediately end the prosecution. Further, the case will continue further if that's the only relief you might have.
So one of the hard parts about talking about this is it's not even law yet, but it's going to be soon. We also have pretty good, belief that it's going to be enjoined probably by a federal judge pretty quickly after it's enacted. So this could play out in the courts for years, but we still want to talk about it because it's very relevant to all of our clients and certainly anybody in the state of Texas who has friends or family, neighbors, employees who are undocumented or have been undocumented. So one of the things you said about the enhancement provisions, Joey, is that if a judge orders him to leave, that's the fascinating part about this rule. That has historically always and only been exclusive to the jurisdiction of federal immigration judges to remove somebody under an order of removal, deportation, or voluntary departure, or immigration authorities at the border. Now it's actually giving a Texas judge or a Texas magistrate power to do this. And one of the many incredible things, it wasn't part of this, part of the preface of this law says, a magistrate can do it at magistration. So share with our people, because we have lawyers watching this, but we also have people who are not savvy. A magistrate is somebody who talks to somebody right after they've been arrested for a crime. Tell them just briefly how that would play out under this new proposal.
So as written here, as soon as an individual is arrested for basically any crime, it looks like there have been some modifications to this between the House and the Senate. And I think what they added was if you are before a magistrate judge, prepared to get a bond set, to post bond and get yourself released from jail, that magistrate now, we're not exactly sure how they would have the proof to even begin this line of inquiry, but They have the authority to basically order you, with your agreement, to remove yourself from the state and end a prosecution under this new act, such as illegal entry from a foreign nation. So you could be arrested on a crime of DWI. A magistrate will be advising you, figuring out what bond to set for your DWI. They might discover you are not in the state lawfully or in the country lawfully. Now we're beginning a secondary analysis that's created by this act, where the magistrate will inquire if you are here unlawfully, and if you are, it gives them the authority to say, basically, we're not going to charge you with this new crime of illegal entry if you promise not to come back and you agree to my order right now in this very moment at the beginning of your case to do so. So that is very unusual.
Because it places the judge on the position of like a plea bargain.
Correct.
Say, hey, would you like me to dismiss this case? I can do that right now. You just have to agree to go back. And what's funny, it doesn't say go back to your country. It says go back, return from where you entered. So
you could officially be, let's say, someone from Guatemala or someone from Honduras or someone from El Salvador, but you entered through a Mexican border crossing, and then at that point, what basically they're saying is that you would be returned to Mexico and not to your native country.
Yeah,
correct.
That's incredible. And what's amazing, the enhancement provision, if I understand it right, Joey, says if you were to agree to that, and again, you don't have a lawyer present, right to a lawyer present with this during your
first time
magistrate.
you're talking to anybody about your recent arrest. You're likely without counsel, depending on what county you are in. There's no right to counsel at magistration in the state of Texas at this point in time. So it could be a defendant without legal advice having basically plea discussions, plea bargains with the court. And if you are ordered or agree to remove yourself from the state, you agree to the judge's order at that point in time to leave in order to prevent prosecution under this new portion of the act. If you are found again in the state of Texas and you did not comply with that order to leave, that can be charged as the third of these newly created crimes called refusal to comply with an order to return to your foreign nation, and that is a second-degree felony. Now, second-degree felonies in Texas are punishable possibly by a term in prison between 2 and 20 years. So it is extremely punitive, and it's really serious stuff that we're talking about here as far as newly created crimes for, again, not being in the state, I guess with proper documentation, proper permission.
Incredible that you could be charged with something and have a judge say, well, I'll dismiss if you leave, and it's only a Class B misdemeanor even if he does charge you. It seems like a small kind of little handshake agreement that you're going to leave the country, and then the punishment is now a second-degree felony. Teresita, you've had a chance to look at this. What are your thoughts on this? What, as an immigration attorney, is there any things that jump off the page to you?
I think that there's certain things that are very interesting because it refers to if the person enters or attempts to enter this state directly from a foreign nation in any location other than a lawful port of entry. So essentially, anyone can enter and they can be caught essentially trying to enter. But what about if somebody entered 10 years ago? What about if they entered 20 years ago? What about, and how do they prove this, right? That's the problem. A lot of times individuals will give all the information that they need in order to find someone criminally liable for any kind of crime in this nature. So if you provide, let's say, your nationality, your citizenship, your manner of entry, your year of entry, at that point you've created the case for them. But essentially I find it difficult for them to prove how all of those factors without you providing that information, essentially from the time of being questioned.
Yeah, one of the things that was kind of impressive to me is, so if this magistrate, you get brought in under suspected, you entered unlawfully, and then the magistrate offers you this deal that will go home and we'll dismiss your case if you agree to go back. It's almost like the person who wrote this had no idea of what an ICE hold does.
Right.
Because Immigration Customs Enforcement and ICE can place a hold on you. Now, the state will release you, the magistrate and the county officials will release you, ICE picks you up, then what happens?
Right, so then you get released, then you get passed over to ICE, and then the question becomes, what happens at that point? You technically have a somewhat removal order, and then at that point, are you now...
Well, he said removal order just by this magistrate judge.
Right, just by this magistrate judge, but now technically, you've already been removed.
Which is not binding on the federal government.
Which is not binding on the federal government, and now...
So if I had an asylum argument, and I wanted to assert that in an immigration court, how would this affect me? Do you see that?
Well, that's the problem, right? Because one of the exceptions doesn't talk about a credible fear interview if it was found. What about if you were paroled out? So many individuals come into the country, they have a credible fear interview to then pursue asylum and then be able to do so, but that doesn't exist right now as an affirmative defense listed as an exception. It does discuss asylum, but asylum approved. not a credible fear interview that was now recommended and will now be moving forward. So that's going to be.
So if the criminal magistrate releases me with dismissing the case, but with an agreement that, an order, I should say, not an agreement, an agreed order that I'm going to leave the country, and then I go with immigration and I have an asylum defense, and the judge releases me on some kind of bond or release, the immigration judge releases me. Is your understanding that now, under federal law, I'm allowed to stay in the country?
On the immigration side, but technically, if you look at this, you're not complying with.
I'm committing a second-degree felony
You're
now.
now committing a second-degree
Even though
felony.
I'm doing exactly what's legally allowed under
And
immigration
now, as
law.
Joey said, a second-degree felony, 2 to 20.
And it seems like part of the purpose of this new act is if you are caught up in any of this process in relation to new offenses, or let's say this goes into effect and one is magistrated like this, it seems like the intention is to not return to Texas,
Right.
specifically. I think somebody could go through this process, agree to an order with a judge, possibly remove themselves to another state without similar type laws. And again, it just seems like the goal is to prevent individuals from residing and staying
In Texas, correct.
Yeah, I noticed this one statement in here talking about abatement of prosecution on the basis of your immigration status determination prohibited. So the criminal, once passed, this law basically says you are not allowed, the court may not stop prosecuting this offense basically because you may have immigration arguments. Is that y'all's understanding of what you're reading here?
That is my understanding.
Agreed.
Okay.
That is my understanding as well.
Well, so, I mean, we don't want to scare people. Obviously, this point is to inform, but people can worry and panic. We know there's going to be plenty of people out there maybe trying to scare people. What do you guys think the likelihood of implementation is going to look like moving forward once the
I
government
think
signs
the
this?
likelihood is that it will be enjoined almost immediately. There are so many.
And when you say enjoined, you mean?
That there will be a stay order,
federal
meaning
court.
this will not be able to move forward. There will be a federal court that will confirm that they will not be able to implement this until this is further reviewed. On a personal level, I think that this is a violation of due process. This is 100% a state versus federal. Immigration is a federal issue at every level.
And I think here, as opposed to some of the abortion-related provisions here in Texas, the issue of standing for any lawsuits challenging this should be pretty straightforward. I don't see it. It's all government agencies and state agencies. So but probably the first person wrapped up in this would have standing to challenge the constitutionality of these acts, and that's going to be the test case, it sounds like.
The federal government has every intention to want to confirm that they are the ones that oversee immigration law, and so I feel that this will be something that ideally will not go forward, and I would be surprised if it does.
Jeff, just on that point, could you maybe talk a little bit, just briefly, about preemption? And I think that's what Teresita was getting to, as far as the doctrine of preemption and how that would be one of the challenges here.
Yeah, certainly we're not constitutional experts any more so than the next lawyer, although probably more than most. So obviously, if the Constitution gives the states, right, basic control of everything that's not given, specifically enumerated and given to the federal government. And so obviously there's a lot of legislation given over the years to what the federal government can do with respect to borders, treaties with other countries, immigration laws specifically always fell for the last 300 years of this country under the dominion of the federal government. So this is the first time that I'm aware of I've ever seen of a state really trying to create their own immigration law.
I think we had that Arizona law in 2012 that was enjoined, and I don't think ever went into effect. But again, it's the objective here by the legislature is if any part of this is struck down, the rest of it remains. And again, that part will also be challenged, the severability aspect of it. So we could talk all day about this. But.
So we don't want people start freaking out thinking they need to move out of Texas, because this could take several years to work its way to the Supreme Court probably before it gets decided. But are there some practical things, just reading this, that you can think of somebody, because people do get pulled over right now on state highways, especially in South Texas by DPS, and ask questions: where are you from? Who's in the car with you? We've had plenty of clients charged with smuggling, both wrongly and correctly. Can you think of any practical takeaways based on just these laws, these laws that are going to get implemented for somebody? If you get pulled over by an officer, a DPS officer, a local sheriff, and they start asking you questions about what are you required to tell them, what would you not tell them?
So in Texas, failure to identify yourself to law enforcement can be a crime. So you must present identification. If you don't have identification, you must present your name, date of birth, identifying information upon request. Anything else, your right to remain silent applies all the time, and we encourage anybody arrested to invoke their right to remain silent. Aside from that basic identifying information, so the officer pulling you over, arresting you, can, look up your history, see if you have active warrants. That's the purpose of that law. But anything else, you do not have to answer, and we just encourage everyone to use the rights that are granted to you, and please do not speak to law enforcement in a situation like this if it's not necessary.
In Teresita, the right to remain silent obviously covers both under federal law and state law, federal authorities and state authorities. And you see play out in removal court sometimes where people or immigrants might give information that, had the government not known that, they don't even know if this person's undocumented.
A lot of times in immigration court, you'll see something called an I-213, and an I-213 is basically a document that outlines questions and answers that were done at the time, typically of somebody being detained or being questioned. So many times, trial attorneys in immigration court will refer to the I-213 because it basically makes their case for them. And it's frustrating because you know that at that moment, that person was just speaking, right? Trying to just divulge information that unfortunately they didn't know was going to be incriminating them, but that really is what happens. There is an I-213 that gets filed with the immigration court that basically outlines all of the information in terms of matter of entry, time of entry, and so many times you think that you're giving approximations and they're taking it as actual literal answers that are then used against you in federal court.
Yeah, I can't tell you how many times, both as a criminal defense attorney and immigration rule defense attorney, I wish if my clients had just not said anything, had they just done the minimum, given their name and date of birth, we would have an amazing motion to suppress, right? Because the officers don't know all this information. It's not illegal to be Hispanic in the state of Texas. It's not illegal to look like, what does a non-American even look like? We have every race and ethnicity represented in this country. So it's really tough for them to stop you and say, oh, I think you're committing an immigration crime. They don't know that. But if you start offering up all this information, so just your best bet is just minimal information given, name, date of birth. That's all you have to give. You don't have to say where you came in, if you're legal in the country, if you're a citizen or not. You don't have to give any of that. And quite honestly, you should be a little offended. I would be offended if they started asking me that, and I would say, it's none of your business, sir. So to wrap it up, takeaways, what we want to share, make sure people know and moving forward.
Just, again, watch what you say to law enforcement if you are wrapped up in something like this. Again, all you are required by law to provide is your identifying information. Everything else, we would encourage you to invoke your right to remain silent and your right to an attorney.
Teresita, would you move out of Texas?
I would not, no. I would stay vigilant, obviously, and just aware of what's coming up. There's 1 in 6 Texas residents are immigrants, and 1 in 6 Texas residents have are either a native-born U.S. citizen with at least one immigrant parent. So we know that this affects so many individuals, so many of our clients, so many of our family members, and so we're just trying to just spread this information, but at the same time, not to instill fear, but just to really just inform.
And maybe this will be the impetus or the motivation for some of you who have pathways to status. Maybe you have a spouse and you've just been putting off filing, or you have something and you've just been kind of hanging on to start moving forward now to get something going. I think the best defense sometimes to any of these things is actually having some kind of documentation, whether it's a work permit or proof that you've got a petition filed pending. A lot of times that can dissuade prosecutors even when they otherwise could file it. So this story is just starting. A lot more is going to develop over the coming years. Stay tuned here at the Peak Law Group. If you want to forward this to friends or follow us, we'd love it. And we're going to keep sharing more information as it comes out. Y'all have a great day.